Hi, I'm attorney Julie Hauff, and today I wanted to talk about in a little detail the recent third DCA case that was issued on attorney's fees. It deals with multipliers, but also has some other issues as well that's helpful all around, even for cases that don't involve multipliers. So this is the Universal Property and Casualty Insurance Company v. Deshpande case that was decided in November of this year. What was appealed was a fee award over $400,000, and that did involve a 2.0 multiplier that had been awarded at the trial court level. The court said, as Universal had argued, was that the award was excessive and unsupported by the evidence. So Universal's expert had provided a line-by-line item response detailing the objections to each of the entries that they took issue with, reducing 469 hours to just over 100 hours in that case. The plaintiff's fee expert, on the other hand, did not prepare a line item analysis and instead did a what the court called conservative, and those are their quotes, not mine, estimate where he applied a 10% across the board reduction. Didn't explain what the reduction represented, but then also said that a 2.0 multiplier was appropriate based on the favorable outcome achieved and the likelihood of success at the outset, and those are two of the three factors. The defense expert, on the other hand, did go into each of the elements of the multipliers and said that there was no evidence presented that a multiplier was required to obtain competent counsel, or that other counsel wouldn't have taken this case only if a multiplier was at issue. So they completely and totally failed to present evidence on that third prong of the test, which all three have to be met in order to get that award. But what was interesting, the court went further on some other issues too, and said that the fee applicant bears the burden of presenting satisfactory evidence to establish that the hours are reasonable, but also that they are expected to exercise what the court called billing judgment, and if they do not, the courts are obligated to do it for them. So it seemed to really take a strong position on the trial courts going in there and editing that time and getting cuts and making sure those cuts are accurately supported, or any fee award is supported by evidence, but then also accurately described and those findings of fact are included in the order. Here, as we've seen in other cases, the trial court was criticized for not making any specific findings as to the disputed time entries, so they found that 10% reduction that they had adopted and applied from the plaintiff's expert to be arbitrary and unsupported. So they remanded the case, and they said they've got to go back and enter an order that follows the evidence that was entered at the time, noting that the party seeking fees and cost had been given the opportunity for an evidentiary hearing. They're not entitled to a second bite at the apple and attempt to prove their claim. So going back and saying it is the only competent substantial evidence that was presented was the defendant's fee expert opinion and their determination that 101 hours was appropriate. So the court is ordered to go back and enter that. Now it talks again about the multiplier issue and saying how it is vitally important. The finding will not be supported if all of the prongs are evidence of all three prongs on the multiplier are not presented to the court and included within the court's factual findings. And then finally, there was another interesting point in there too, where it talked about reversing some costs that were awarded to the plaintiff's experts who never testified at trial and who were never deposed. And the court went on to say, generally, it's not appropriate to tax as costs the fees of witnesses who are neither qualified as experts by the court nor testify at trial. They recognize that under certain circumstances, those costs may be taxed, but the trial court has to determine exactly which expenses have been reasonably necessary for an actual trial, including expert witness prep costs. They want the court to reconstruct a trial strategy that a reasonable party would have developed in an actual trial and award costs on the basis of that strategy. And again, since there were no factual findings made as part of that order, that part of the order was remanded for the court to go back in and take a look at the evidence and make a finding. So what we take away from that, again, if someone is seeking a multiplier, the defense expert needs to talk about why all three prongs are not met. The plaintiff's expert, if they skip over any of the prongs, they don't use substantial competent evidence to establish that, it's not going to be upheld. And then that line-by-line objection is extremely important. Surprising that it wasn't used at all by the plaintiff's expert in this case, but I think the defense expert did it right here. So a lot of important points to take away as you are evaluating claims for fees, but then also getting ready and prepping for your fee hearings and your cross of the plaintiff, as the plaintiff's attorney, as well as the plaintiff's expert. Any questions, you know where to find us. Thanks so much. Have a great day.